Leading up to that election, quite a whole lot has been happening, but do you know the development coming out of Kogi State? Still on the aftermath of that poll. Joining us to look at the outcome is John Oloyede. He's a legal practitioner. Good morning and thanks for joining us.
Good morning.
Now, the Electoral Act is one key document that most people have been trying to understand in the face of what has happened in Kogi State, the unfortunate loss of the candidate of the All Progressives Congress in that particular election. First, before we go into the Electoral Act, how did that news come to you?
Well, I mean, a lot of things in the political circles in Nigeria no longer surprise me as a person, but this came as a rude shock. I mean, well, it's not the making of any man. In the realm of law, we talk of acts of God. This is one act of God that messed up all kinds of human projections. And so, just like any Nigerian, I was really shocked.
When you use the word messed up every kind of projection, if you put that with what lawyers like yourself have been about in this development, is there a way out of this for the party or for the nation?
Oh yes, I mean, for every problem, whether legal or otherwise, there will be a solution. We've had a situation in this country where the doctrine of necessity came in handy at the appropriate time, and a major constitutional crisis was solved. This is another quagmire, but it's not so difficult as, I mean, to think that Nigeria will not get out of this. It's just a state, and well, the laws may not adequately cover the ground in this area, but I mean, with a little bit of tinkering by the courts, I guess we should be able to.
Why do we have to tinker? Let's look at section 181 of the Constitution, where it talks about if someone is sworn in as a governor, I mean, elected as a governor, but has not taken the oath, and then something happens and he cannot take that oath, eventually his deputy should step in, and then the State Assembly will have to go about getting another deputy. How does that tie into it? Would that work in this case where the election was declared inconclusive?
Definitely not. This is, I mean, a lot of people have volunteered opinions on social media and in print media, trying to stretch this section 181. I don't think that section 181 envisages the situation we have on our hands. The operative words there are someone who has been validly declared as validly elected. In this situation, unfortunately, INEC in its own wisdom declared the election inconclusive. That means nobody has been declared as a winner of the election. So section 181 does not operate to take care of this situation at all.
What about the Electoral Act? If you look towards section 36(1) and even 33, how does this, because 33 tells us about political parties changing candidates,
yes,
and specifically 36(1) is on the death of a candidate, where is if after the time for the delivery of nomination paper and before the commencement of the poll, a nominated candidate dies, the Chief National Electoral Commissioner or the resident electoral commissioner shall, being satisfied of the fact of death, countermand. In fact, that word, a lot of people who are not lawyers would want to have your explanation of that particular section.
Yes, I mean, I don't think there's any contradiction in terms between the Constitution and the various provisions as from sections 31 to 36 of the Electoral Act. Now, here is a situation where they are talking about substitution of candidates. Now, what section 36(1) talks about is a situation, a lot of people were worried that, assuming for the sake of argument that INEC says, well, this man is dead, there is the issue of the time that is provided in the law for the nomination of candidates, party primaries, where candidates have to be voted, and God forbid that a party that was on the way towards winning an election will be disqualified simply because of an act of God. Because if, for instance, yes, APC can substitute, I have no doubt about that, there can be substitution of candidates. But then the candidate you want to substitute must have gone through primaries for that purpose, governorship, not as a deputy governor. Then after that, his name must have been published so many days prior to the elections. Now, do we have that number of days? Those are the issues. But the issue here is about countermanding here relates to a situation where, if there is sudden death, then all those requirements of the Electoral Act, as per party primary election, publication given a number of days, they will not apply to APC in this matter. APC can simply, that's where the Chief Electoral Commissioner can countermand all those provisions relating to time, and then can say, okay, just forward any name you want and we'll take that name, and that person can carry on with the election.
In this case now, okay, we've looked at these two sides of substitution. What about the role of INEC calling for, should the supplementary or runoff go ahead, or should they call for an outright rerun of the election?
Well,
what does the law have to say about
now, you see, the quagmire we find ourselves in, it flows from, it tapers from the Rotimi Amechi case in Port Harcourt. There's a precedent, Supreme Court precedent, which a lot of people have criticized. Are we talking about party supremacy or the candidate's supremacy?
And that has been a situation with the last assembly where they said it wasn't the party, it was the individual, it wasn't the individual, exactly. It was the party.
So there is a flux in the state of law now. Now, can INEC just say, the people vote for the party, not the candidate?
Based on the court's judgment.
Exactly, based on Amechi's case. Or is it the candidate per se? Now, it rubbishes the freedom of individuals to pick a candidate, to vote for a candidate of their own choice. If you go by way of the decision of the Supreme Court, ordinarily, if the people matter in any decision in this country relating to elections, the Rotimi Amechi case has no precedent and should not stand. And what is the whole essence of an electioneering process where the people's choice is not respected? In Rotimi Amechi's case, it doesn't matter. The person that the party presented was only presented by the party that the people have voted for. At that point in time, one would have expected that the court would have ordered a rerun. That, okay, Amechi, go there and contest. This other man cannot do it. But now, Audu is dead. He has garnered some votes. Yes, it's a joint ticket. But can anybody say, with all sense of responsibility, that James Faleke, or who is his running mate, was the one who got those votes? That is the germane question. Going by precedence, INEC can conveniently say the election can continue, provided that James Faleke will now step in because he had a joint ticket. Then who chooses the deputy governorship? Because this is not a situation where somebody had been declared as the winner covered by Section 181. This is a situation where there is no winner yet. So is it James Faleke that will now choose a deputy governorship candidate to run with him and conclude the election? Methinks the proper thing is for the election to be rerun all over again, with liberty to APC to present another candidate under Section 136(1).
Now, going further, let's ask the question, because this is just not the first time we have heard INEC talk about supplementary election. Where does this sit in our books, the Constitution, or even the Electoral Act? Is there provision for supplementary election?
You see, one thing we have to, there is no law that is totally cast in stone. Now, the Electoral Act, for instance, what you just read, the Chief Electoral Commission can countermand. There's a wide discretion. For instance, the use of, what's it called? It's not computer, what's it called?
Voter's card?
The electronic device.
The card reader.
The card reader, thank you. The use of the card reader. The law gives them a discretion where it fails. So when you say, does this sit in our law? There are certain words that are not clearly spelled out in any law, right? But because they are human beings and they are conducting a process that involves humans, a lot of discretion is given to them to decide I mean, for instance, this issue of having a rerun or supplementary in 91 units. The APC on one side will say, look, there are only 25 persons who have been accredited to, 25,000 persons who have been accredited to vote in all those units. Now, the APC candidate is leading by 41,000 votes. But there are about 49,000 persons. I was watching your analyst yesterday on channels, and there are about 49,000 persons who are registered to vote in those units. But obviously, the 49,000 persons are not voting, only 25,000 maximum. So assuming that all these 25,000 people vote for the PDP candidate, he still would not be able to secure the majority of votes cast as against the APC candidate. That's APC perspective. The INEC perspective is we have 49,000 persons registered to vote. If there's a rerun, they may all of them may come and be accredited, and so they will have another opportunity to make up their minds, and they all may just vote in favor of the PDP person. Meanwhile, the PDP per se, not INEC now, their perspective is, oh, the 91,000 units are the areas of strength for us, and those areas, why were they cancelled? Everybody has a perspective. Definitely, two perspectives out of those three are wrong. One perspective will be right. The best way to test which perspective is right or wrong is to take it back to the electorate.
And let them decide.
And let them decide.
Someone sent in a message here. It says, Section 178, subsection 3 of the 1999 Constitution might have to come into play.
I can't immediately recall what is in Section 178.
I thought you'd have that in
If
mind.
you elaborated further, maybe I'll be able to break it down.
But let's see. The whole thing now looks as if it's at the hands of the electorate to decide.
Yeah.
But how quickly would that decision be made? Because if we go by the Electoral Act and the Constitution, it's supposed to be 14 days.
14 days.
So would it be 14 days? Would it be 90 days? Or would the Attorney General have to step in here to say exactly where we're going?
No, I don't think. Some people have suggested that the Attorney General, it's a constitutional issue that the Supreme Court should be, an issue should be submitted to the Supreme Court to decide.